Good morning, New York. I am Anna Terry Flores. I am a former state senator from Miami, Florida. More importantly for you all, I was part of the Unified team in my high school. Our team went on to win the national competition that year. So good luck to all of you today.
Good morning, New York. My name is Gus Chin. I'm a municipal judge in Utah.
All right, please introduce yourselves.
Hi, I'm Jennifer Sachs.
Hi, I'm Zarina Rahimi.
Hello, my name is Ian Huang.
My name is Jason Nguyen, and we're Unit 5, and our teacher is Mr. Pittman.
All right. Well, let's do question number 2. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to a state Bill of Rights? What are the differences between positive and negative rights? And which are more important to the preservation of liberty? You may begin.
George Mason stated that all men are by nature equally free and independent and have certain rights of which, when they enter into a state of society, they cannot by any compact deprive or divest their posterity. Mason believed fundamental liberties, which prevent the government from having too much control, need to be explicitly stated in a Bill of Rights to satisfy Thomas Hobbes' social contract theory. Before ratifying the Constitution, Anti-Federalists argued that a Bill of Rights was necessary because the Supremacy Clause, in combination with the Necessary and Proper and General Welfare Clauses, would allow implied powers that could endanger rights.
As Patrick Henry wrote in his Anti-Federalist Papers, all rights not explicitly and unequivocally reserved to the people are implicitly and incidentally relinquished to the rulers. As necessary, inseparable from the delegated powers, Mason countered that the Constitution, as constructed, would suffice as protection, and a enumerated Bill of Rights would only serve to limit the rights of people. Writing from France, Thomas Jefferson weighed in, adding that a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference.
We agree with Thomas Jefferson and Thomas Hobbes that the people of every government on earth are entitled to a Bill of Rights, as the absence of such document would allow the government to infringe on the people's otherwise inalienable rights. Thomas Hobbes' social contract theory postulates that citizens submit to a government under the condition that the government will protect their liberties. A Bill of Rights ensures that the government will uphold their part of that contract.
If we accept the Hobbes theory, citizens have a separate social contract with their state and federal government, which is why each individual right must be incorporated into the state in order for it to be protected by state governments. As decided in Barron v. Baltimore, the court uses a process of selective incorporation on a case-by-case basis where specific rights were deemed implicit in the concept of ordered liberty.
Under the American system, a system of federalism, citizens also enter into a separate social contract with their state. Unlike the National Bill of Rights, which is a general and often vague statement of positive and negative rights, a state Bill of Rights is more extensive and specific. The advantage of having a National Bill of Rights is its widespread guarantee. As Gordon S. Wood of Brown University stated, in our own time, the Bill of Rights has become even more important judicially than the Constitution itself. This means that the Bill of Rights is used more as a template for the Supreme Court to ensure that rights are being protected.
A disadvantage of a National Bill of Rights is interpretation of each of those rights can change over time, so it may be outdated. With the current state of politics and the partisan mentality in the government, it is near impossible to change or rework the Bill of Rights. In a state Bill of Rights, however, it is somewhat easier to change the document because states provide a simpler and quicker method for amendments, and places such as New York that allows for regularly scheduled constitutional conventions.
Ultimately, a Bill of Rights is an enumerated list of positive and negative rights that, as Jefferson says, no government should refuse or rest on inference. Immanuel Kant's concept of a fundamental human worth or dignity is used to justify both the negative rights, which impose a negative duty on all others not to interfere with some form of liberty, and positive rights, which require the positive assistance of others. When these rights come into conflict, it is important to decide which is more important to the protection of human dignity. In the case of Epperson v. Arkansas, the negative rights of the freedom of speech and religion were pinned against the positive right of the state to prescribe a curriculum for public education.
As Judge Flores wrote in a decision, the state's undoubted right to prescribe the curriculum for its public schools does not carry with it the right to prohibit, on pain of criminal penalty, the teaching of scientific theory or doctrine where a prohibition is based upon reasons that violate the First Amendment. In this case, the negative right was proved more important to the preservation of liberty as it protected liberties against government interference or personal freedom. As former President John F. Kennedy said, the Bill of Rights is a guardian of our security as well as our liberty. Thank you. We're now ready for follow-up questions.
Thank you. What a wonderful opening statement. Of course, the Supreme Court has recognized a number of individual rights that are not found explicitly in the language of the Constitution. So, for example, in the Obergefell decision, the Supreme Court recognized that individuals of the same sex have the right to marry. Even though the Constitution doesn't explicitly state that. When and under what analysis is it appropriate for the court to recognize new individual rights that don't appear in the text of the Constitution?
I would say that these new rights that are established through judicial review would fall under the Ninth Amendment, which states that people retain rights that may not be enumerated in the Constitution. And the reason why I think that the founders set that up was because they knew that the zeitgeist of the time was going to change in the future. For example, I'm sure that the founders never could have imagined the Roe v. Wade case about the right to have an abortion, or even the case that you mentioned about same-sex marriage. And the reason why the founders set that up was because they knew that the times were going to change and that things that they could not anticipate were going to happen.
I'd also like to add on to what my colleague Jennifer says, and agree with that. The founders of the country knew that that the zeitgeist would be changing, and that is why they made the Constitution so vague in the sense that we'd be able to change it and able to interpret it in a way that, in the way that the government of the zeitgeist sees it. And I believe that with judicial review, the reason for judicial review is for the same exact reason, because as a society continues to grow, so will new problems that need to be dealt with constitutionally, like, for example, vaccines. And just with this whole COVID situation, I believe that it can lead to many issues and that aren't going to be in the Constitution and that need to be interpreted through judicial review.
Of course, I completely agree with my colleagues, Jennifer and Zarina. Of course, examples would include women's suffrage, African-American freedom, and their ability to vote. These circumstances were not thought of during the time, or they were chosen to put to a side in order to get other states to come into the Union. The founders created this Constitution as a way to pick just a little from each side so they can become a union. But all these issues will become an issue for the future. So today we have so many issues, even today, including race, education, LGBTQ+, that still need to be figured out.
And adding on to what my colleague Jason said, the founders, there was only a certain amount of amendments made. I don't think the founders would have thought of the 14th Amendment, the Equal Protection Clause. That gave a lot more rights for African Americans. And even the Civil Rights Act of 1964, that gave more rights for the African Americans too. So with the 9th Amendment there to be more vague, it gives the opportunity for more rights for different people or different races as time moves on.
Thank you.
Great. So you all mentioned and went through the lists of rights that are protected in the Bill of Rights. Are there times where sometimes those rights can be limited? So what limits should be placed on the Bill of Rights? And how should a court analyze when limits are justified versus when perhaps those limits are not justified?
Yeah, so We agree with the concept that that rights can only be limited when there is that strict government interest, and we've seen this in a lot of cases. For example, when religion is pitted against education, that comes into play a lot. For example, in Abington District v. Shemp, they ended up limiting the right to religion in order to create a more inclusive school environment, and I think that that's going to come into play again when we see the question of the COVID vaccine. I believe Zarina started to bring this up before, how that may end up being an issue that may end up having to limit some rights.
Adding on to what adding on to what my colleague Jennifer said, another right would be privacy. And although it's not really said in the Constitution, in the case of New Jersey v. TLO, they limited the students' right to privacy by allowing the school to search them, which kind of goes against the right to unwarranted search, which but the government found it was important to keep the school safe, so they found they gave the right to the school to search students even though it's an invasion of their privacy.
In a case such as Shank v. United States, in that circumstance, the idea of freedom of speech, something that we hold so highly of, was limited because in the Supreme Court deemed that for the greater good, the idea of the greater good, that negative right should be limited just for the greater good of the entire population and the continuation of the Union.
Yeah, and I would just like to quickly add on that a quote from John Stuart Mill that says, I believe that it says, my right to, or my fist ends where your nose begins. And I think that this is very important because the reason why these, the reasons why amendments in the Constitution or the Bill of Rights are limited is mainly because it affects other people. For example, freedom of speech, or freedom, or maybe like freedom of religion. In the sense where, first off, freedom of speech, I like to talk about Brandenburg v. Ohio, and I think this case is very well known in the sense that this, what happened in this case was a person, I believe that a person was, their right to freedom of speech was limited due to fighting words. And I think this is important because this really helps to show when the Bill of Rights can be limited.
There won't be enough time for my question, but I'm going to throw it in the event there is a spot of time. You mentioned judicial review. Has the court always gotten it right in their process of judicial review?
No, I don't think that the court has gotten it right, but that's also why so many cases have been overturned. For example, I believe it was Debs v. US that was overturned later by Tinker v. Du Bois, and that had to deal with a lot of the freedom of expression. And again, I do think that that was based on the zeitgeist of the period. For example, there was a different set of justices that ruled in Debs v. US against the freedom of expression. And sorry, may I finish? I believe that's time.
Please go ahead.
Okay, thank you. I believe in Debs v. US, they ruled against the freedom of expression, and then in Tinker v. Des Moines, they ruled in favor of freedom of expression. So I do think that since the process of judicial review is not exactly easy, but easier to overturn than amendments, that's why a lot of that is used, and so they can correct their mistakes in the past.
Thank you.
Congratulations to New York, Long Island, New York. Thank you so much. Great presentation, and congratulations again to teacher, Mr. Pittman. And now it's time for the judges to give you your feedback.
What a spectacular presentation. That was just absolutely awesome. I loved your opening where you really rooted every statement in this philosophical view of the Hobbes social contract. So you really had a strong intellectual and philosophical basis for the reason for Bill of Rights, both at the federal level and the state level. That was really just absolutely terrific. And then in your answers to our questions, really incredibly strong use of both the language of the Constitution, the Ninth Amendment, as well as case law, the concept of judicial review, Brandenburg versus Ohio, Fighting Words, Schenck, Addington, great use of case law. Weaving in the 14th Amendment to the Ninth Amendment was really terrific as well. Recognizing that there are hard issues in the future like race, education, LGBTQ, women's suffrage. Just a sweeping, really broad presentation that kind of hit on every note. Really spectacular job. You should be very proud of yourselves. You've thought a lot about this. You've approached it very intellectually as well as very lawyerly and scholarly. Superb.
I absolutely agree. You all did a fantastic job. And in a very short amount of time, showed us that you knew the subject matter. You had constitutional and case law references to very quickly back you up. You went with, well-known cases, but you went with a bunch of cases that are, people cannot easily cite, and you all did. And I love how everyone participated, how you all have a great grasp of the subject matter. And it looks like you all just, you get along well, and you've practiced this before, figuring out who's going to talk when. I mean, you all did just a great job. Excellent presentation.
I agree. A very lawyerly approach in addressing the follow-up questions, particularly as you referenced authority, the Constitution. I'm glad I got my question in the last few seconds because it demonstrated your understanding of judicial review and the role that justices play and the interplay between judicial review and legislative amendments to the Constitution. So wonderful job. Well done. Good luck to you all with your future.
Thank you, and congratulations to your teacher, Mr. Pittman, as well.
Really wonderful. And thank you, judges, for that fantastic feedback.